Well, Poppy, the Supreme Court sort of taking the middle ground here. This is the case involving the subpoenas out of New York City from the DA there. The Supreme Court saying that the president is not absolutely immune from these criminal subpoenas. However, the president does have some recourse to fight the subpoena. The Chief Justice in this case writing this opinion, this is a 7-2 opinion. It's actually the judgment is joined by Justices Kavanaugh as well as Justice Gorsuch here. Let me read you what the Chief Justice wrote. This sort of sums it all up. He said, "We reaffirm the principle today and hold that the president is neither absolutely immune from state criminal subpoenas seeking his private papers, nor entitled to a heightened standard of need." So by that sentence, it seems that this subpoena could go forward. However, the Supreme Court is sending this back down to the lower court, sending this to the district court for further consideration, because as noted in this opinion, they said that while the president is not absolutely immune, a president, not just President Trump, but any president does have some recourse here. They can bring up issues, they can fight this. So these tax returns will not be released to the grand jury, at least right now. They have to go back to the court to fight it out at the district court, but saying it could happen in the future.
And Jessica, how long does that take?
Well, that's the thing, Poppy. You know, the president has been fighting for months, I think going on more than a year now, throughout this entire thing. And I think one thing is for certain, we will not see any decision in this case likely before the election, less than 4 months away. These things take a lot of time, briefing schedules, argument schedules back at the district court in New York City. So it's fair to say that Vance, the prosecutor in New York, likely won't see it before the election, and the public certainly will not see it before the election, because they likely wouldn't have anyway, since this is for grand jury proceedings, which are kept in secret, Poppy.
Very significant. Jessica, we'll let you keep reading. We'll get back to you in a moment. Let's go to Jeffrey Toobin. Jeffrey.
All 9 justices reject the position put forth by the president's lawyers in this case. All 9 justices say that the president does not have absolute immunity from a subpoena. And all 9 agree that the case has to go back to the district court. This is a legal defeat for the president, but it may be a practical victory. The idea that the president can't be subpoenaed is completely rejected by the Supreme Court, and that even the 2 dissenting justices agree on. All 9 also agree that the case should go back to the district court. The practical victory for the president is that the legal proceedings will continue. It seems unlikely, given this opinion, that the president will ultimately be able to stop the disclosure of these events to the grand jury in Manhattan. But it's going to take time. I mean, this process will begin again. The district court will get briefings. They may hear evidence. That will be appealed to the Second Circuit Court of Appeals. And then the losing party will likely go back to the Supreme Court.
Jeffrey,
all of it will take a while.
Can you explain why? Because to get to the Supreme Court, you go through lower courts. So why is it going back?
Because the president, the opinion says, Chief Justice Roberts' opinion says that, like any other defendant, he can go in the district court and say this is harassment, it is overbroad. They can't make the same arguments that they made in this case. But there are arguments that any defendant can make to try to stop a subpoena. They usually don't work, but they are arguments that are raised in court. And, federal courts don't work overnight. It will be several weeks of briefing on both sides. It will take time for a district court judge to issue an opinion in this case. That decision will then certainly be appealed to the Court of Appeals. That will have to be briefed. And here we are in the middle of July, the election's in November. It seems to me very unlikely that the actual documents will be turned over to the grand jury before November. And as we've been pointing out all morning, there is no requirement or even permission for public disclosure of these documents at any point.
Okay, we'll get back to you on the justices that joined in the majority, because that's fascinating, too, in just a minute, Jeffrey. But let me get to Caitlin Collins at the White House. Caitlin, any reaction from the president?
We're still waiting to hear from him, from the White House press secretary, but the Treasury Secretary, Steven Mnuchin, did have what appears to be an ill-timed interview where he was on another network and he was asked about this decision that just came down. He said he couldn't comment on it. He said, as he understood it, it didn't involve the Treasury, which it doesn't. But he goes, I would say the only thing I do agree on is that when things go to Congress, they tend to get leaked, and when things go to grand juries, they don't. That has played such an important factor in what Jessica and Jeffrey were saying, that if this House Democrats case gets ruled on, there's a chance you could see those financial records a lot sooner than if they go, of course, to Vance, and what happens with the grand jury and the chance that maybe he doesn't even get them before the election. So that's really important to keep in mind, is whether or not the public is actually going to see these financial records from the president. But Poppy, you know, one thing to look for in the president's reaction to this ruling is, how does he feel about the two justices that he appointed to the court ruling for this favor? Because you know how he views the court and how he views it as his people, the ones that he appointed, and that's why he's made this argument, you know, I need to be reelected so I can put more of my people on the court. And that's even how some critics of Kavanaugh and Gorsuch saw them, as Trump people, Trump justices, and making this.
It's a great point. I was just going to, sorry to step on you, Caitlin. I think it's a really great point. And you had the Chief Justice writing, as Jeffrey mentioned, in the majority opinion here, we reaffirm the principle today and hold that the president is neither absolutely immune from state criminal subpoena seeking in his private papers, nor entitled to a heightened standard of need. And if I could bring in our historian here, Douglas Brinkley, on this, we knew this may be coming from the president's appointees to the court, Kavanaugh and Gorsuch, because I think Gorsuch really tipped his hat in oral arguments when he brought up the case of Clinton, former President Clinton v. Jones, and said, how do we as a court, how does the high court here avoid the conclusion that the president, in that case, Clinton, wasn't subject to some special immunity, but here is? There, they sought the deposition of a president while he was serving. Here, they are seeking records from third parties.
That's right. I mean, Ruth Bader Ginsburg said what's good for the goose is good for the gander, and talking about the Clinton v. Jones case. This is, in my mind, a very big victory for Cyrus Vance Jr. in New York. I mean, they went all out to get the president's financial records and his accounting ledgers. And lo and behold, eventually they're going to get them. Really what we're talking about is time. And what does this hurt politically Donald Trump right now? Yes, it hurts because he now has to live in a kind of paranoid world that knows somewhere down the line, and maybe after November, but when he's a private citizen or in his second term, that this could break open on him and break open big. The Lord only knows what Donald Trump's tax records and financial papers are going to show, because he had his fingers in so many strange businesses. And, you know, we've always been wondering about things like Trump University and how could that have even existed. And so I think this is a nightmare for Donald Trump, but a containable one.
Douglas Brinkley, so sorry to interrupt. Hold that thought. We do want to get back to our Jessica Schneider, who is at the Supreme Court. And Jessica, I believe we're going back to you. Do we have the decision in the second case, the House case for the president's financial documents?
We do have that decision, Poppy. It was just released. And just like in the case involving the district attorney out of New York, for now, these financial records will also remain blocked, the ones that the three different committees led by Democrats are seeking in the House of Representatives. The court taking a similar approach here as they did in this other case out of New York City. And the vote breakdown, the exact same as well, 7-2. And the conservative justices joining with the liberals, except for Clarence Thomas and Samuel Alito, they're dissenting. And pretty much the reasoning is the same, very similar here in this House case, basically saying that the court below, in deciding that these documents should be handed over to these congressional committees, that the courts, as the court put it, did not take adequate account of the significant separation of powers concerns implicated by these congressional subpoenas for President Trump's information. So once again saying that, maybe this request could go forward, but not right now, and it's something that needs to be further considered at the lower courts. I mean, there was an interesting part in this opinion, Poppy, that said, the way the House has approached this in asking for this wide array of documents, which even Justice Kagan expressed some concern about at oral arguments, saying that maybe this was just too broad of a request.